Because, Your Honor, I object to
What
the fact
do you
that he's
not
calling
understand?
it no
Sir,
RV.
your objections mean shit to me. So you keep saying, I object, I object, I object. I don't care. I don't care what you're objecting to. I'm going to hold you in contempt the next time you cut her off.
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying.
All right, folks. Today's case features yet another courtroom showdown with a so-called sovereign citizen. This man walked in thinking he could challenge the judge using made-up legal ideas, but the judge wasn't buying it. No drama, no back and forth, just clear and firm decisions. Watching the judge calmly take control while this man tried to argue his way out with confusing theories was a lesson in how real courtrooms work. Honestly, it's hard to understand why people think these approaches will get them anywhere. Law doesn't bend for imaginary rules. What do you think, was the judge fair? Or should he have been even more direct? Let's take a look. Now here's where it gets tiring. The man simply won't stop talking.
File?
Yeah, yes, absolutely. I actually discussed before I crossed.
But the court reporter needs to take you up.
Here, you don't have to be at the podium, but at least have a seat at that table where that microphone is.
Press forward, and I'm under duress. I'll cross.
You're under duress. How are you under duress?
Well, Your Honor, it's stated in a motion I have. There's actually a word that says unsigned by the judge. I have lawsuits filed on all of this stuff right now, which I know that they received.
Hold on, brother. Wait. I'm just asking you to have a seat at the chair with a microphone.
Oh, I understand. Okay. Just trying to protect myself.
That's fine. Just make sure you talk to the microphone.
Absolutely.
Okay. All right. You can sit down. Okay. So I think this is your motion to dismiss, right?
Yeah, I have a few in there that I've been repeatedly trying
Okay,
to be
well, which one do you
dismissed.
want to start with first?
Well, the recent one I filed, the motion to reject the swearing in and all that, based off the fact that, like I said, I was sent a default motion that, I don't know how it even got sent out past the day, but it was never signed or anything. I was also defaulted out the fact that there was a citation that never even presented a court appearance.
Okay, hold
date
on.
and
You're
all
giving me
that.
too many issues. You're talking about swearing in. You're talking about a default judgment. Which? Just pick one issue. We're going to deal with them one at a time. So what do you want to deal with first?
Well, my main motion. Well, yeah, the default.
Okay, so was that on the civil infraction, failed to disclose the CPL?
I suppose that's what it was under, yes.
Okay, what? Don't suppose, it's your motion, brother. Tell me what it is.
Well, it keeps getting
I mean,
set
that's the only
aside, so I
civil
have
infraction.
numerous lots of stuff.
Hold on, that's the only civil infraction I see with your name on it. So I'm just confirming that we're talking
Yes,
about
it was
that
over.
charge.
Yeah, sure.
Okay. So do you know why the default was entered? Did you miss a deadline? Did you
Well,
not?
I was notified. I was called by people that I know within Huron and the police chief stating that I had a missed appearance date. I never had an appearance date scheduled, but I went back looking at the citation. There was no date, and actually how fast it got issued raises real concerns to me. And then once I received the default in the order.
Hold on. Let's take one thing at a time. So you said you never got an appearance date.
Correct.
Do you have a copy of the ticket? Because I've got a copy
Yeah, I
of the
said
ticket.
it's in there. It's attached to my motions.
Okay. Do you have a copy
Yes,
of the ticket?
I do.
Okay. Then I'm going to ask you to look at that copy of the ticket. Because my copy of your ticket says contact court for appearance date.
It says contact court for appearance date. Where it says appearance date on or before, there's nothing.
Okay,
They
but
didn't
it
give me no
says
time frame.
contact court for appearance date. That means the monkey's on your back to contact us.
I will also on the bottom of the tickets it says if you fail to contact court within the specified amount of time. There was no specified amount of time on here. I had no idea when I was supposed to contact court. I was dealing with trying to get my
Well, let
attorney.
me ask you this: did you contact the court?
I was again, as I said, I had no sort of any time frame
Mr.
to
Purcell,
contact the
Mr.
court.
Purcell, this is going to go a lot easier on everybody if you just answer the question I asked. I'm going to give you plenty of chance to give me any argument you want to give. Okay? So don't feel that you have to force your argument into every question I ask. The question was, did you contact the court?
Well, Your Honor, I would have contacted the court if I had a specified.
That's a yes or no. So I'm going to take that as a no. You didn't contact the court. So after 14 days on a civil infraction, if we don't hear from the defendant, we enter default.
It was less than that actually when I was defaulted, Your Honor.
Less than that from what?
From whatever this was issued. And like I said, I was contacting
Well, once
attorneys.
again,
The judge asked a basic question. Did he skip court on purpose? Instead of answering, he went off on a long-winded speech, avoiding the point completely. These kinds of responses don't help his case. Whether he's confused or just thinks he knows better than everyone else, it clearly isn't working. Here's the next part. At an earlier hearing, he asked the court to undo a default decision. The judge agreed. But now, he's back in court acting like he didn't understand what happened. It's frustrating. He got exactly what he requested.
The same one you got is dated February 3rd.
Correct.
Okay? So that's when it was issued, February 3rd.
Correct.
So when was the default? When did you get notice of the default?
Actually, I received, I'm sorry, I know I got the thing in the mail. When did I get this? This says that, I don't think it specifies a date.
Well, did you make a note when you received it?
This told me, this said I don't remember exactly what date I received this in the mail, but this was scheduled for March 8th.
Okay.
So that was even less than a month.
Well, what is that that's scheduled?
This says it was for my order, the motion affidavit saying that I was defaulted and saying that I needed to pay bond and a warrant would be issued. And I said,
Okay.
again, that was never.
And that's dated what?
This was dated 3/8. I needed to appear
Okay.
on or before 3/8.
Okay, so that was March 8th. You were defaulted February 22nd.
Okay. Which then, again, there was no dates. I had no nothing. I had no
Okay.
notice
Well,
of any sort of
once again,
appearance.
you're not hearing what I'm telling you. The monkey was on your back. The ticket clearly said you contact us. You never did.
And it also specifies right here, if you fail to appear by the date specified, and then on the bottom one, even for the other one, if you fail to answer a citation by date specified, there was no dates.
Okay.
There was no dates.
Okay. Do you have anything to add?
I do, Your Honor.
Go ahead.
Mr. Purcell brought this up when you were in front of the Honorable Judge Martin. She did set aside the default and civil infraction, irregardless of whether or not he showed up.
Which I object to the setting
Sir,
aside.
do not interrupt the lady. Did she interrupt you?
Oh, yeah.
Then don't do that. Let's be civil. Go ahead.
Thank you, Your Honor. Judge Green, Mr. Purcell did bring it up again with the Honorable Judge Green, and she declined or denied his motion based on the fact that it was moot because Judge Martin set it aside.
So the default's already been set aside.
Yeah.
Brother, why'd you just waste 5 minutes of my life?
Since March 14th.
Which I object to that because there's...
You object to your motion being
No, I
granted?
object to that.
He's still playing the victim. These repeated delays waste time, money, and patience. Honestly, it raises the question, should courts keep giving them chances or just take stronger action right away? Let's keep watching. Eventually, the judge put his foot down. To be fair, the judge's instructions could have been clearer at one point, but that doesn't excuse what followed. The man kept making random arguments and refused to stay on track. At this stage, he either needs real legal help or just needs to stop interrupting. If you can figure out what point he was trying to make, you're doing better than most of us. At least the judge finally brought things back under control.
Listen, she tells me Judge Martin set aside the default based on your motion.
Yes, but I was never told any of that prior to any of it.
So you want to argue about the fact that you got what you asked for?
No, what I'm saying is the fact that the due process was violated is what happened in this whole problem. When I was defaulted, due process was violated.
So what? She set it aside.
Listen, okay, it was set aside to cause damages to me because of what happened with the default.
Well, explain to me how you were damaged.
First off, there's threats made against me, right? Clearly, he's threatening me to issue
No.
warrants,
I didn't ask you
threatening to
about
pay
threats.
money.
I said, how were you? You said you were damaged. I'm asking you, what was the damage?
By the fact that I was threatened to come in and pay money or warrants.
How was that damage?
And I was being threatened by Huron Police, which I have on record.
What's the damage?
What do you mean? The fact that I had to come in and pay money, or I would have been, there had been issued
What money
warrants.
did you pay?
Huh?
What money did you pay?
$280. I had the receipt and everything. It was all attached to my motions. They just keep trying to set it aside, and Judge Green never said a word to me
Stop.
about any of that.
It's been set aside. Counsel just said, Judge Martin set aside the default. So what that means is, procedurally, it's like it's a brand new file. Understood?
Yeah, but that's according. Yeah, but that, especially now with the new shove-out overlay, that's just saying that she's just trying to set it aside that there's no issues.
She didn't try to set it aside. She sat it
But she
aside.
can't. She can't just set my rights aside.
She's not setting your rights aside. She set a default aside because you asked her to.
Well, so if it's set aside, then the money should be returned, correct?
Well, I don't know. Did she address the money?
No, she never did. No one did. I
Sir?
explained in my motions.
Sir, I'm going to hold you in contempt.
This next claim was at least different from the usual routine. Said one officer told him he could drive, while another gave him a ticket. It wasn't the usual confusing talk, but it still didn't hold up legally. He didn't mention he had a corporal and wasn't licensed properly. Case closed. Are you convinced by that excuse? Because I'm not. Next, he actually said, "Judge, I don't like your response. That's not how the law works." It's almost like some of these people read questionable advice online and expect it to hold up in court. It's frustrating and honestly a bit sad.
$100. The second contempt a day in jail. Are we clear on the ground rules for my courtroom? Is that a yes for the
Yes,
record?
Your Honor.
Okay. I'm giving you all the time you need to talk. Don't talk over her.
Okay. I understand. I'm sorry. There's just been a lot that's been going on with this.
And I'm the first time I'm seeing him, so I'm trying to get to the bottom of
You're right.
it. All right? So we started with what motion do you want to talk about first? You said your motion to set aside the default. That was granted by Judge Martin, is what I'm hearing from the prosecutor. So that motion's done. Would you agree?
As long as my money gets returned, then I guess it's taken
At some point, trust me, your money will either get applied or returned. Next motion you want to talk about.
The dismissal based off of fundamental violations of my fundamental rights and due process.
Okay, well, tell me more.
Okay.
You have, hold on, let me just cut to the chase. You have more than just the fact that you think you have a right to travel.
Yes, Your Honor. Actually,
That's denied. I'll just cut to the chase. That's denied. I don't buy into that argument. Now, you can appeal that decision to the circuit court. You understand how that works? District court decisions you can appeal.
absolutely.
Okay, hold on. I've denied that motion. We're not going to talk about that motion because I've denied it based on your argument that you have a right to travel and don't need a license. Is there anything else you want to hang your hat on for dismissal?
Well, I do object to the setting aside of my motion, Your Honor.
I'm not setting aside your motion. I'm denying your motion.
Well, denying. I object to the
You
denying.
can't
of my motion.
object. You can appeal.
I'm just
Okay.
letting you know, I'm stating for the record that I am objecting to your denial of my appeal.
That's fine. Circuit court judges have bills to pay too, right? So you appeal me to the circuit court. Do you have any other argument why these cases should be dismissed?
That's absolutely. Well, honestly, Your Honor, like I said, I even have both lawsuits. They've received my lawsuits to the Huron Township Police Department overall.
Hold on. I don't know anything about lawsuit. How would you suing the township work as a reason to dismiss these charges?
Because the initial traffic stop and everything was an unlawful stop from the get. I was
Okay, but that's got
retaliating.
nothing to do with your lawsuit. That might be the basis of your lawsuit. So you want to talk about whether or not there was a valid reason for a
Yeah,
stop?
absolutely.
Then make the argument.
Yeah, Your Honor. So prior to me being pulled over by this officer, I was actually in contact with several law enforcement officers that are friends, and actually two that are currently working within Huron that had confirmed I had every lawful right to be doing what I was doing. The one even pulled up to me and my wife at a gas station in town, and we are in Sibley and Middle Belt, right near actually where I got pulled over. And we had discussed it and talked about it, went on about our day, and this was all prior to this incident. I had had two other interactions with this officer where I had specifically told him I've already been confirmed and doing lawful. I'm well within my lawful rights. I have it documented. You need to go talk to the sergeant that I've been talking to, and a couple other buddies. Right, I gave him that opportunity. It was shortly after, and this I had had that confirmation well prior to me even being pulled over. Okay, so then this officer seen me leaving my house, pulling off my dead end dirt road, proceeded. And like I said, I even told him I've already had this. I've already addressed this. You need to go talk to the sergeant.
Right.
Chose not to. Pulled me over, walked up, just started demanding ID and everything from me. He wouldn't identify himself, none of that good stuff. And then now this is where it's all led to. And I informed him, I have body cams, I have my own recording. And like I said, I have a lot.
Okay, but you started out by saying you wanted this dismissed because there was not probable cause for the stop.
Correct.
Okay? And then you went on to tell me how there was obviously a difference in opinion within the department about whether or not what you were doing was legal or not.
Well, I
Is that
specifically
a fair
stated.
summation?
What was that?
Is that a fair summation of what you just said? Some of the officers that you talked to said you could do that, and obviously the officer who wrote you the ticket didn't think you could.
Correct.
Okay? So that's a difference of opinion there, which has very little, if anything, to do.
We should really be teaching basic legal understanding in schools, so people stop showing up in court with these ideas. What do you think? Through it all, the judge stayed calm and handled the situation like a pro. He didn't let the man dodge responsibility. He made it clear. If you don't have the proper license or paperwork, you're breaking the law. That's it. No officer can override the law with a casual comment. So was this guy more reasonable than others we've seen, or just another one trying to push the limits? Either way, thanks for tuning in. And if you like this kind of content,
I'm going to let the prosecutor explain her position on probable cause.
Absolutely.
Go ahead.
Thank you, Your Honor. Defendant is requesting this court dismiss the case because of the accusation that operating an ORV on the roadway constitutes a blatant violation of his First Amendment rights and an improper attempt to regulate his constitutional rights. In his most recent motion, he does accurately cite Terry v. Ohio as controlling. This was plainly a Terry stop.
Well, hold on. His argument is there was no reason for the stop.
He does cite Terry v. Ohio in his motion.
Okay.
Because people submit that the investigatory stop exception in Terry v. Ohio controls the validity of the traffic stop. An officer may stop and briefly detain a person on the basis of a reasonable suspicion that criminal activity is afoot. Defendant claims that he was stopped without legal justification. Rather, defendant was stopped for operating an ORV on a roadway in violation of MCL 324.81122 as adopted by the Courtroom Township Ordinance. Pursuant to the United States v. Ferguson, so long as the officer has probable cause to believe that a traffic violation has occurred or was occurring, the resulting stop is not unlawful and does not violate. On authority of state law and township ordinance, a person shall not operate an ORV which is not registered upon a public highway, street, or right of way. On the date and time of the offense, the defendant operated an ORV which was not registered, specifically an 18B on Riverboat Road, a public highway here in Township. Additionally, during the course of the investigatory stop, the defendant failed to provide a valid driver's license and failed to immediately disclose that he was a valid CPL holder and carrying a firearm, which is why he was cited.
All right. So,
Which I object to the
hold on. All right. So the one misdemeanor is operate the ORV on the roadway, and the other one is fail to display a valid license. Okay. All right. So that's her response to your argument. They didn't have probable cause. What's your reply to her response?
Well, I object to her terms of operate. There's no evidence that I was operating anything.
Okay, let me stop you. I killed that when I said the whole traveling thing doesn't go anywhere with me. Operating and traveling, as you define operating, or as you define traveling, we define it operating. So hold on. I've already ruled on that issue. You can appeal that decision to the circuit court. We're not going to plow that field again. So now we're talking about probable cause. What I just heard was the township has an ordinance that says nobody can operate an ORV on a roadway. Would you agree that's an ordinance in the township?
Your Honor, I may agree.
Yes or no?
Yes, I agree with that.
Okay, stop. If that's a valid argument or ordinance, and when I say valid, I don't mean if it's constitutional, if it's stood the test of a challenge. I mean if it's on the books. All right. If it's a valid ordinance and the officer sees you doing what that ordinance says you can't do, and he pulls you over, that's plenty of probable cause for the stop. So your motion to dismiss for lack of probable cause is also denied. You need me to clarify that ruling for your appeal reasons.
Yes, actually, because Your Honor, I object to
What
the
do
fact
you
that
not
it's calling
always,
it an
sir?
ORV.
Your objections mean shit to me. Okay, I don't care what.
Don't forget to like and subscribe. Appreciate the support and see you next time.